Reyna.
Mr. Reyna, we had requested some judgments from the past hearings he's had and held, and we were provided those today. One of them, and I had received already one. I discussed that with my client, and he kind of doesn't like the way I'm approaching everything, and doesn't like the way or he feels that I'm not representing him.
Mr. Reyna, come on down.
So we might want to talk to him because he's asked me to get off the case. And I told him that's something you have to discuss with the judge. And for the record, we have been relayed an offer to my client.
All right. So, Mr. Reyna, are you Mr. Reyna?
Yes, miss.
All right. So it appears to the court that you do not want to come dressed for trial when you're supposed to be dressed for trial.
Well, believe it or not, Ms. Boyd, I wasn't aware of this trial in the first place. And
no, because here's the thing. Firstly, when a deputy at the jail tells you you're supposed to be dressed for trial, you're dressed for trial. And when your time, you were told before and you didn't do it. And guess what? If you ever come back to this court where a deputy at the jail has told you to dress for trial and you're not dressed, you know what's going to end up happening? You're going to be going to trial in that red jumpsuit. And you know why you're going to be going to trial in that red jumpsuit? Because it's going to have been your choice. I am not having you come back to this court again where you're pretending as though nobody told you you had a jury trial. The other thing, you're saying that your attorney is telling me that you want another attorney?
That's correct.
All right, then you need to hire one. Do you understand?
I don't have any support issues. Support at all as we speak right now at the moment.
What support for what?
Ordinary to hire an attorney.
Oh, well.
Buckle up, guys. Today, we are stepping straight into a tense courtroom moment where things begin to unravel quickly. Right from the start, the defendant challenges his own lawyer, claiming he is not being represented properly. The judge immediately steps in, shutting down the confusion and making it clear that this is not a casual discussion. This is serious business. The tone is firm, and the power dynamic is instantly established.
Must have. This is a third-degree felony. It may be bumped up to a second-degree felony based upon what's in the indictment. This attorney would not have been appointed to your case if he didn't have the qualifications to be on this case. I don't allow attorney shopping in this court. Whoever comes up on the wheel, that's who your attorney is. The state will tender an offer to your attorney because I require the state to tender an offer. State can make an offer and say, we're offering 20 years. The state can say they're offering the maximum. Guess what? Your attorney has absolutely really no control over what the state is offering.
So what's
even if your attorney were to go to the state and say, well, these are the weaknesses in your case, and this is what my client is willing to accept, the state can still say, I am not going to offer your client what he wants. The only thing I will offer you is A, B, or C. And your attorney ethically is obligated to tender that offer to you. Now, you can accept it or not. That's completely up to you. There are certain rights you have when you're charged with the offense. One of them is whether or not you will accept an offer or not, and whether or not you will testify at trial.
Now, the judge shifts into explanation mode. But make no mistake, this isn't a soft conversation. She breaks down how the legal system works, especially when it comes to appointed attorneys and plea deals. The key tension here is the defendant wanting control, but reality hits hard. The state controls the offer, not the lawyer. It's a moment where expectations crash into reality, and the judge firmly draws the line.
Case carried at least prison time and not probation.
Here's the thing. You will have to speak to your attorney. What I can tell you is there are certain cases, number one, that you're not eligible for probation. There are certain cases that if you go to a jury trial and if you are found guilty, you're not eligible for probation. There are some cases that if you go to jury trial, maybe you're eligible for probation from a court. But I cannot tell you whether or not, just based upon looking at your case, which would be the indictment for me, whether you're eligible or not. What I can tell you though, usually if you have a repeater count and you go to a jury trial.
Here, the defendant starts worrying about the consequences, especially the difference between prison time and probation. The judge carefully avoids giving specific predictions, but delivers a strong warning. Repeat behavior can drastically reduce the chances of receiving leniency. There is a subtle shift in tone. It is no longer just about rules and procedures. It is now about consequences. You can feel the weight of past mistakes beginning to press down on the entire situation.
About that, and I'm sure your attorney will tell you whether or not you're eligible. Think of criminal history this way. If you have somebody that you loan money to, right? Let's say somebody comes to you and they say, can you loan me $50 and I'll pay you back next week? And you say, yes, I will loan you the $50. What are you going to use it for? Oh, I got to pay my electric bill, which that would be a great, good electric bill these days. And that person gets the $50 and they don't pay you back. And you're just, you said you pay me back on this day, you're not paying me back. That person comes to you for a second time and said, look, I'm in dire straits. They're about to cut off my electric bill. I need $60. And you tell them, you know what? I gave you $50 just last week and you never paid it back. And they're like, I know, I'm so sorry for doing that, but I promise you this time I will pay it back and I really need the $60. So you loan them $60 and they don't pay it back. And then they come to you for a third time. You may say, I'm not gonna loan you anymore. I don't care what your problems is because I've loaned it to you 2 times before and you haven't paid it back. Sometimes people view criminal history that way. And when I was a prosecutor, sometimes people would view criminal history that way. They would say, you know what? I gave you probation before, you didn't do well on it, and you pick up another case. I gave you probation the second time, you didn't do well on it, and you pick up another case. So maybe that could be a reason.
What stands out here is how the judge uses a relatable analogy to explain criminal history, comparing it to lending money repeatedly to someone who never pays it back. She explains why the system becomes less forgiving over time when the same patterns continue. It is a simple but powerful moment. The analogy transforms legal reasoning into something personal, helping both the defendant and the audience understand why trust eventually runs out.
Cases and then come to felony court and say, oh, I'm qualified. That's not how it works. So he's tried the necessary cases. And if you are upset by the offer that he is tendering to you, no, that is the offer that the state has made. And in this court, I require everybody to treat each other with kindness. So I guarantee you, when the state made him that offer, the state wasn't mean. The state just says, this is the offer I'm making. And I expect you to treat your attorney with respect. I'm sure your attorney will treat you with respect. But again, if you want a different attorney, you need to retain an attorney. So that means you need to go out and hire an attorney. And if you don't have a...
Part 5. Now the judge circles back, reinforcing her authority and setting clear expectations. She emphasizes the qualifications of the attorney and demands respect inside the courtroom. There is no room for attitude or excuses. The message is crystal clear. Whether the defendant likes it or not, this is the legal representation provided unless he can afford to hire another attorney. It is a reality check delivered with precision and zero tolerance.
Going to trial dressed in that red uniform, and you and I both know that red uniform has several meanings attached to it, just the way the orange ones does and the blue ones does. The blue one for females, orange, just regular inmates. The red, gang member, age issue, in admin segregation. Yellow with stripes, pregnant, or just yellow, pregnant. Tan or grayish looking color, trustees. So if you want to come to trial dressed in red, that is completely up to you. Do you understand?
Yes, miss.
Do we understand each other?
Yes, miss.
Do you understand the offer that the state has made to you? That's either yes or no.
Yes.
Do you need to confer with your counsel anymore on the offer that the state has made to you? And if you would like to make a counter offer, I'm sure if you would tell your attorney, well, I want to accept this, but this is what I will accept. That's what's called a counteroffer. But what that means is you're telling the state, I'm not accepting your offer. I will only accept this. So that means that you're rejecting the state's offer, and it may or may not appear for you again. Do you understand?
Yes.
And I'm sure this attorney will be able to tell you what your range of punishment is in this type of case. I cannot tell you that because I don't know the facts of your case. The only thing I have before me is an indictment. You understand?
Yes.
Do you need to speak with your attorney some more? Do you need to see what evidence the state is saying they have?
No, miss.
Have you already seen that?
Not quite yet, but yes, I have.
Mr. Gomez, will you let him see that since we're all...
And tension spikes again as the judge warns about courtroom appearance, even mentioning the impact of wearing a red jail uniform in front of a jury. It is not just about clothing. It is about perception and consequences. Then she pivots to legal strategy, explaining plea offers and counteroffers. This segment blends discipline with decision-making pressure, forcing the defendant to think carefully about the choices ahead.
Are you the same Jamal Coleman who was placed on deferred education in 2019 CR 11674 for the offense of aggravated assault with a deadly weapon on November 5th, 2020 for a period of 8 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 2 on or about the 7th day of June 2023 in Bexar County, Texas. The defendant, Jamal Trayvon Coleman, did then and there fail to submit to a drug test in violation of condition number 2.
How do you plead to that? True or not true?
True. The state will waive and abandon the other allegations.
All right, did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, fine you guilty, and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, ma'am.
A new phase begins as another case is called, and things start moving quickly. The defendant admits to violating probation by failing a drug test. The judge makes sure he fully understands the seriousness of the situation. This admission could potentially lead to significant prison time. The atmosphere becomes heavier as the stakes are no longer just theoretical. This is a critical turning point where accountability becomes unavoidable.
Are you agreeing with that?
It is, Judge.
All right, Mr. Coleman, raise your right hand for me, please. Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. State your name for the record.
Jamal Trayvon Coleman.
All right, Mr. Coleman, do you want to go to prison?
No, I do not.
Then why do you keep coming before me with violations?
I have an issue with drugs.
I mean, I know that, but I've sent you to different places and you're just not doing well. And so I don't know if I can help you or not. I don't know if you want the help. I can put people in whatever class that's available for you. If you have a drug problem, I can put you in a class for drug issues. But if you go there and you sit there and you internalize, but the first thing some problem comes before you, your answer is, oh, let me use drugs.
May I speak?
Yes.
I didn't get a chance to. I didn't really complete the first program, the safety that you put me in.
Mm-hmm.
I don't know if you remember, but I had a colostomy bag.
Yes, I do remember you.
So I got my colostomy bag removed,
mm-hmm.
but I didn't stay at the safety facility. They took me to an infirmary unit, and so I've kind of missed the whole entire program. I think I was only in the program for about 2 months,
mm-hmm.
if that. So I didn't really get a chance to be in the program.
So you had a colostomy bag, and again, you're using drugs.
Yes, ma'am.
That doesn't work well for anybody's health. And I will tell you, I have some friends who previously were addicted to drugs, and now they've been clean and sober for about 30 years. And they will all tell me, Stephanie, I can no longer abuse my body because I abused it so much. So guess what? They don't do ice cream. They don't do any of that. They're always working out, fruits, vegetables, their proteins. That's it, because they put their body through the ringer. And how old are you?
I'm 26.
You putting your body through the ringer. And I will tell you, meth not only affects the mental health part of it, but it affects your heart, it affects your liver, it affects everything else. You understand?
Yes, ma'am.
Probation. I'm sorry, do you have any gang affiliation?
I did when I was younger, not currently.
And what was that?
Blood.
Oh. He's saying that he's not a gang member anymore. I don't think felony drug court will accept him because I had put on here at one time refer back to felony drug court and they said no. Am I correct?
That's correct. I believe they will not accept him back.
And will ISF accept him with his gang affiliation?
We'll have to give him evaluate.
All right. I'll deny the motion. Alternate amend conditions to include ISF dual track. If he's not accepted by ISF, then it's going to be safety.
Yes, ma'am.
Is there anything else you need from the court?
No, ma'am.
Am I going to see you back again here for this nonsense?
Got it. No, ma'am.
Do you have the tools you need to not use?
Yes, ma'am.
All right. Do you have a support system at home?
Yes, ma'am.
Who's your support system?
Grandmother, my mother, my father, and my elderly grandparents.
All right. So you need to stop disappointing them because I'm sure each time you use, your mom's heart breaks, your grandparents' hearts break, your dad's heart probably breaks. You understand?
Yes, ma'am.
Nobody wants to, because you never know if the last time you use is the last time you use. Nobody wants to be called to have to identify your body because you're the person on the news who's on the street and they'll just say drug overdose and then they'll go on to the next person. You understand?
Yes, ma'am.
All right. Good luck to you.
In the final stretch, the judge shifts from authority to concern, confronting the defendant about his repeated drug issues. There is frustration, but also a clear attempt to push him toward making a change. She highlights the health risks, the impact on his family, and the harsh reality of addiction. The moment ends on a sobering note. This is no longer just about the courtroom. It is about life, choices, and survival. If you found this breakdown insightful, make sure to like the video, subscribe to the channel, and we'll see you in the next video.